Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. The defense has filed a motion to suppress and memorandum in support regarding arrest warrant on the 14th of November 2024, pursuant to Judge Steven Hippler's prior order that is the deadline for motions to suppress to be filed in this case. This particular motion was signed by both Jay Logston and Ann Taylor. It is a very long motion. Provided a link to you in the description where you can read it for yourself. And once again here, as we have seen in prior motions to suppress, we've reviewed for you, the defense is once again intermingling their arguments from their pending Frank's motion for a hearing which has not been granted as of yet by Judge Steven J. Hippler. And perhaps problematic for the defense is that the motion for a Frank's hearing, where they have incorporated by reference attachments and argument into this motion to suppress rather than filing a standalone motion, was stricken by the court on the 22nd of November 2024. And you can read that order if you follow the link I've provided here. The defense was required to file an amended memorandum in support of their motion for a Frank's hearing, which they did on the 26th of November. The problem being, however, this motion to suppress and other motions to suppress that intermingle the Frank's argument are based on the stricken first motion and memorandum in support of a Frank's hearing and exhibits thereto. Now, everything is under seal. We don't know how much the second memorandum for a Frank's hearing changed the first, but we can surmise from Judge Hippler's order of the 22nd of November that the amended motion was probably a lot more slim than the very large motion that was filed that the court deemed needed to be refiled because it had something like 2,000 plus pages of exhibits that were duplicative items and were not properly cited to the record to point the court to where the court wanted the defense to look to consider whether or not Mr. Kohberger should receive this Frank's hearing, which, as we've stated before, is very difficult for a defendant to qualify for. Nonetheless, this motion to suppress raises some rather interesting points on the part of the defense. If you look at page 2, it says here, on December 28th, Trooper Leary of the Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Corporal Brett Payne. On December 29th, 2022, at 4:44 p.m. Eastern Standard Time, 1:44 p.m. Pacific Time, a magistrate in Pennsylvania issued a search warrant for 119 Lambsden Drive, the home of Mr. Kohberger's parents, where Mr. Kohberger was at the time of his arrest the following day. On December 29th at 2:22 p.m. Pacific Time, which for some reason the defense leaves out that this would have been 5:22 p.m. Pacific Time, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. So if this is correct, it appears the Pennsylvania warrant, which relied on the warrant in Latah County, actually was signed first. This is an opinion I give pursuant to the Constitution, First Amendment, but you look at the items at the bottom of page 2 and tell me what your thoughts are relative to the same. Throughout this motion, the defense raises other reasons why the evidence that was taken as a result of Mr. Kohberger's arrest should be thrown out of the case, and why Idaho's exculpatory rule as opposed to that of Pennsylvania should apply here. There's a difference in the legal standards between the two states. This will now conclude this episode of the Indie Zone. Thank you as always for joining us here today.